Go ahead, Robin. We're going to commence the meeting. This is call to order the meeting of the Tennessee State Board of Equalization. I'm David Lillard, Vice Chair of the Board. Robin, hope you will call the roll.
All right, Miss Burchett?
Here.
Commissioner Geragano? Secretary Hargett?
Here.
Miss Merrick is absent. Comptroller Mumpower?
Here.
Treasurer Lillard?
Here.
Do you have a quorum?
Okay, then item number 2 is public comment period. Mr. Pope, recognize those that have public comments.
The board did receive 3 timely requests for public comment. Starting, I believe that you have that in your packet as well. We have 3 speakers who wish to comment: Mr. Kelsey Jones, Mr. David Scruggs, and Mr. Brett Carter. I believe Mr. Carter and Mr. Jones are here in person. I ordered them in order of agenda item. Each member will have 2 minutes in order to make their comment. But Vice Chair, the discretion is up to you to extend that time. I will be back here and I will raise my hand when they've reached 2 minutes for your identification.
Okay. Mr. Kelsey Jones, forward.
Mr. Chairman and members of the board, good afternoon. It's a pleasure to be with you all and to good to see you again, I should say. My request to offer comments is directed solely to the 2 contested case items that I have under agenda item 9. I believe it is. So if you want to hear a brief summary of my explanation of the case, I can take questions, or I can wait until you've called the item in particular. It's entirely.
Just go ahead and tell us your views, okay?
But just briefly then, there are 2 matters under agenda item 9 in which I represent the taxpayer. The first of these is Cross Creek, Tennessee LP. This is one of 6 apartment properties that in the course of the 2022 Knox County reappraisal was singled out for unlawful assessment increases through the practice of sales chasing by the assessor and the County Board of Equalization. The initial decision and order, which is we're asking to be reviewed in this matter, dismissed the taxpayer's complaint without examining evidence and concluded that as a matter of law, that the taxpayer had no remedy beyond a hearing on value. It was said many years ago, before my time, if that tells you anything, in the 60s, that it's more important in the property tax assessment process to achieve uniformity than it is precision in value. This case is a direct challenge to the benefits of reappraisal that achieve uniformity. Sales chasing is an anathema to uniformity in a reappraisal. And that is basically our issue on that particular case. The status of the case is that it's been referred for a hearing on value. But before, and that's all well and good at some point, but we believe that the equalization issue should go first, and that there should be an in-depth look at whether indeed there was unconstitutional, unlawful assessment discrimination through these sales chasing practices. The second case I have involves a church here in Davidson County, Westminster Chapel, that is seeking relief from the statutory effective date provision that imposes a May 20th deadline for an exemption applicant, church or charity, to file an application. Otherwise, they must.
All right, you had 2 minutes here. Do you want to give him a little bit longer to finish up here? Is that okay? All right, let's go ahead, Mr. Jones. Go ahead and finish up here.
That may be enough to say, except to point out that the administrative judge overlooked an important item of proof that I will try to show if you all grant review, and also overlooked the impact of the 3 precedent cases going back a few years that have the last good precedent, saying that where there is some act or direction from the that causes the delay in filing the application, then relief may be granted to the strict application of the May 20 deadline. Thank you very much.
Thank you. Sounds
Thank you. Our next speaker, I have an order of agenda items, is going to be Mr. David Scruggs. I believe he's appearing telephonically over Microsoft Teams. Mr. Scruggs requests to comment on 2 items. I believe he does have 2 minutes per agenda item. I will hold my hand up again at the 2 minutes for agenda item 9, and then again at the 2 minutes for agenda item 10. Mr. Scruggs, if you want to give us a shout, and just before you begin, just make sure we can hear you so that doesn't eat up any of your time. He was muted for a moment.
Can
Mr.
you hear me?
Scruggs? Yes,
you
we
hear
can
me
hear
now?
you now.
Yeah, I'm sorry that I'm not on via virtual, but for some reason it wouldn't let me in. I'll talk to you about that later, Mr. Pope. But I want to
Okay.
talk about the issue of the ability to have relief now that the Assessment Appeals Commission has been abolished. As you all know, it was abolished July 1st, and it reviewed decisions of the administrative judges. Since then, there's been 5 appeals filed with you in 10 months. And the one you heard in October, I wonder about the procedure because it seemed that only Vice Chairman Lillard had read the appeal. And I just believe a more meaningful review process needs to be instituted. It costs about $25,000 to $50,000 to go to Chancery Court. And most taxpayers can't afford that. And I did a review of the assessment appeals actions for the last 2 years. In 2022, they had 23 appeals, and they remanded or modified 7 decisions, which was 31%. In 2023, they had 18 appeals, they modified 9, which is 50%. So errors are committed by the administrative judges, and I'll be glad to tell you what those errors were if you're interested. But what I'm saying is I think the system ought to be, and that you seem to be gravitating toward that, give the taxpayer a chance. All members of the state board should read the appeal. I'm not saying you have to read the whole record, but read the appeal. Also, I think a petitioner ought to be given 3 to 5 minutes to tell you why you should hear the appeal. And then you vote whether to hear the entire appeal or just part of the appeal. I know all of you are busy, so I would suggest if you decide to hear it, delegate it to the executive secretary. He's very well versed in these matters. Usually it's just an obvious error by the taxpayer, and he could make a recommendation to you at your next meeting for you to decide. But once again, there are math errors, there's failure to apply equalization ratios, there's failure to acknowledge floodland, there's double deduction of taxes, which was against the assessors. And all kinds of errors that are obvious that have to be corrected. You shouldn't have to spend $25,000 to $50,000 to go to Chancery Court. I would ask you to institute this so that taxpayers will have a relief valve without going to Chancery. Thank you for your time, and thank you for letting me speak.
Thank you, Mr. Scruggs, for your point on that. Let's see, do you have anything in the next 2 minutes on the other items, on item number 10 on our agenda or anything?
No, Mr. Lilla, I thought that was another appeal. That concludes my remarks.
Okay. All right. Very good. Thank you.
Our last identified speaker or a public commenter for this afternoon is going to be Mr. Brett Carter.
All right.
Ladies and gentlemen of the board, Brett Carter of Nashville Bar. I represent the appellants related to item 10 on the agenda. It's a request for reconsideration. It's a little bit of a unique posture to be before you, but it relates to appeals that were attempted to be filed for the 2022 tax year as a reasonable cause appeal, but were rejected by the executive director and not assigned an appeal number. So that they can be considered by an administrative law judge. Reasonable cause appeals for the 2023 year were filed and accepted. We're not saying that the executive director did anything wrong. I think he was following the guidance from the State Board of Equalization. But we believe that guidance is a little bit more narrow than it should be because Section 67.5.1412E of the Tennessee Code generally requires taxpayers to file reasonable cause appeals by March 1 of the following tax year. but it specifically says that the board shall accept reasonable cause appeals up to March 1 of the subsequent year, but it does not prevent the board from exercising its discretion to take appeals that might be made after that. We submit this as an instance in which an appeal should be accepted after the March 1 deadline. In both of these appeals, the taxpayers had requested amendments to existing appeals for prior tax years, that those amendments be added to the appeals that were pending before the state board. We have written documentation that's in your record that shows that those emails were sent, accepted by the state board. They were accepted by the counties. They had knowledge of it. And so this was done in 2022, well in advance of that March 2023 deadline. And those emails are part of your submission, and the state board's website acknowledges that those 2022 appeals were submitted, that they're on the website still. Because those 2022 appeals were submitted before that March 2023 deadline, we submit that under section 67.5.14.12E, that the board is required to accept it. This was not the first instance when we attempted to reiterate this issue in early 2024. And so we think it's a different set of circumstances that when we would typically apply that March 1, 2023 deadline. And so we think, even if you're not required to accept it, which we believe that you are, we think you do have the discretion to accept that appeal. And we think based on the taxpayers' continued effort to try to get the 2022 appeal before the state board, that the facts in this case are different and distinguishable. And if I might just have
Well, your time's up, but do you want to give them just a minute to finish up? Okay, let's finish up.
What I would say, I just wanted to point this out. I think this points out an issue with Rule 10, which provides for the amendment of appeals. You know, the effort was made by this taxpayer to amend the appeals in this case, and ultimately they weren't added to the appeal. We think that maybe the state board should revisit that, whether some clarity needs to be done out there, because when you look at the record, we think this taxpayer did everything that it could to try to get March 22 in before you, and ultimately, we're continuing to try to do that today. We appreciate your time.
So stay right there a second. Since we're here now and everything on this issue you're raising, I want to ask a couple of questions here. It's going to come up anyway later on during our consideration.
Yes, sir.
In your letter to the board, you cite significant to the state board's consideration of this matter is the fact the state board's own records indicate that both taxpayers submitted notices of appeal well in advance of the March 1, 2023 deadline. You cite Exhibit C to your letter, and Exhibit C is attached here to it. And help me out, I couldn't find in Exhibit C anything that puts us on notice about that 2022 year. These are appeals that were filed with the ALJ for 2020 and 2021. But I'm overlooking something about that, because you're citing it as authority for the fact that you told everybody back at that date, when those appeals were pending, that 2022 was going to be part of the proceeding. And I can't find it's what I'm saying, looking at it.
Yes, well, Exhibit C, I'm not sure what Exhibit C was intended to be email correspondence that came from the taxpayer representative that said, we're requesting that the 2022 appeal be added to the 2021 appeal. And I'm not sure why that's not necessarily what you're.
It's just an email, thing that was filed with the either board or the ALJ, but it doesn't refer to the 2022 year. You're saying in your letter that it does, but.
Well, I guess when I saw what you had there, that's a printout from the state boards. It shows that the 2022 appeal, when you go to the very bottom of that, it shows what appeals were added to that pending appeal for 2021. It may have been 2020 for the prior year, but you'll see that 2022 appeal at the very bottom. And so that correlates with email correspondence that the State Board of Equalization had that received from Mr. Dugan that went to the state and the county that said, we want to amend the 2021 appeal to add 2022. And so the reason I printed that out, as I was trying to point out that this is the state board's documentation that shows that they had notice of the 2022 appeal. That's what I was pointing out. And I can supplement if I have not provided the right emails, I can get those to you.
We'll talk about it here in a little while, a little bit further. I'm looking at pages that are Date stamped to 28, 29, 30, and 31 in our record for the meeting today is what I was looking at. So we'll talk about that a little bit later on in our proceedings, okay? Thank you, Mr. Carter. Anybody else have any questions? Follow up with them. Okay. Thank you, sir, for being here. Okay. Anybody else, Mr. Pope?
Those were the only commenters who requested to make public comment at this meeting.
Very good. All right, the next item is item 3, review of the minutes of October 16, 2023 that were in your packet. Is there any amendments, clarifications, et cetera? The
There
minute?
is one clarification I do want to raise your attention. Yes, as October 17th, the meeting was in fact on October 16th, as well as was raised our attention. There was error in the motion to adjourn, and we've corrected the error to note that the motion was made by you, Vice Chair Lillard, to adjourn last meeting. And second, I believe, by Commissioner Jaragana. We've updated that, but the minutes are otherwise identical as previously sent out.
Those corrections, then the chair would move approval of the minutes of October 16. Is there a second? Second by Commissioner Jaragana. All in favor signify by saying aye. Aye. Those opposed, no. The ayes have it and items approved. Next item is item 4, review and approval of assessment designations. Presented by Macy Brower, Assistant Director, Division of Property Assessments. Yes, sir.
Mr. Vice Chairman, members of the board, thank you for your time this afternoon. I'm pleased to inform the board that 4 individuals have successfully completed all the requirements and supplied all documentation necessary to receive the Tennessee Master Assessor or TMA certification pursuant to State Board Rule 0600-4, the Assessment Certification and Education Program. The individuals are Davidson County employee Kenneth Drake Wallace, Davidson County employee John Carter Ruth, Montgomery County employee Derek Flanagan, and Division of Property Assessments employee Brett Bombick. The division has provided memos recommending board approval of TMA certifications for these individuals. I'll answer any questions you may have.
Any questions of Mr. Brower at this point? All right, seeing none, we want to extend our congratulations to all of the persons who have achieved the Tennessee Master Assessor designation. Is there a motion to approve?
Motion on the item.
Motion, is there a second?
Second.
Second. All those in favor signify by saying aye. Aye. Those opposed, no. The ayes have it and the matter is approved. Thank you, sir. All right, the next item is item number 5, review and approval of reappraisal plans and programs. Represented Mr. Brower, also the Division of Property Assessments. Mr. Brower.
Tennessee Code 67-5-1601 requires each county to prepare a plan of reappraisal for approval by the State Board of Equalization. In 2024, 13 counties completed reevaluations and submitted plans for the next reappraisal cycles. Also, 2 counties have requested to revise their previously approved reappraisal plans from 2022. Those counties are Smith and Lawrence. They both are requesting to move to a 4-year reappraisal cycle. The division has reappraisal plans from all 15 counties that have been reviewed for content and accuracy. The division has provided a memo recommending board approval of these reappraisal plans. I will answer any questions you may have.
Questions of Mr. Brower about item number 5 here. Seeing none, is there a motion to approve?
No.
Motion by Commissioner Jaraganos and
Second.
second by Assessor Merchant. All right. Okay, all those in favor signify by saying aye.
Aye.
Those opposed, no. The ayes have it and the matter is approved. All right, item number 6 is the next item, review and approval of the report of the personal property compliance. Mr. Brower.
State Board of Equalization Rule 0600-5 requires each county to annually submit a plan for tangible personal property audits to the State Board of Equalization for approval. The Division of Property Assessments have received plans this year from all 95 counties that have been reviewed for content and accuracy. The complete plans are filed in the DPA office. The division has provided a memo recommending board approval of these tangible personal property audit plans along with a list of the 95 counties, the audit methods selected, and the number of accounts scheduled for audit. I will answer any questions the board may have.
All right, do we have any questions, Mr. Brower, in regard to the items presented under item number 6 on our agenda here? All right, seeing none, the chair would move approval of these items. Is there a second? Second by Secretary Hargit. All right. Seeing no questions, all those in favor signify by saying aye.
Aye.
Those opposed, no. The ayes have it. The matter is approved. Thank you, Mr. Brower. The next item is item number 7, review and approval of the 2023 tax aggregate report, included separately with your materials for the board meeting today. Mr. Pope.
This is a rather large packet, represents the aggregate assessment information for the prior tax year. The report is actually compiled and created on my behalf, generously from the Division of Property Assessments. So I have Mr. Brower up here as well if you have any additional questions. On behalf of Mr. Breyer and I and the Division of Property Assessments, I would ask that you find the report acceptable and approve it. Thank you.
Any questions, Mr. Pope or Mr. Brower? All right, seeing none, is there a motion to approve the items for item number 7?
So moved.
All right, motion, is there a second?
Second.
Second, Ms. Burchett, okay. Seeing no further discussion, all those in favor signify by saying aye. Aye. Those opposed, no. The ayes have it. Item 7 is approved. Item number 8 is review and approval of resolution certifying 2024 appraisal ratios and review of current value updates, which is 14 through 19 in your board materials. Mr. Brower.
The Division of Property Assessments has completed its statutory obligation to conduct appraisal ratio studies in all counties every 2 years. Additionally, there was one county that was a possible current value update in 2024. Stewart County's overall median ratio was below 90% at 0.5992 and requires an update. The factors required to update Stewart County to current market value have been provided to the board for approval. Finally, the ratios of the 13 reappraisal counties are at 100% and are also included in this report. In the remaining 45 counties, there was no scheduled activity for 2024. Ratios for these counties remain the same as last year, keeping in compliance with state law and the policy of this board and the DPA. The division has provided a memo recommending board approval of the 2024 appraisal ratios, as well as factors required for the updating of values in Stewart County. I will answer any questions the board may have.
Questions anyone has, Mr. Brower, about this item? All right, seeing none, is there a motion to approve the appraisal ratios and review of current value updates and other items presented on agenda number 8?
Make a motion to approve.
Ms. Burchett approved. Right. Motions to approve. Is there a second? Second by Secretary Hargit. Seeing no further discussion, all those in favor signify by saying aye.
Aye.
Those opposed, no. The ayes have it and the matter is approved. Thank you very much, Mr. Brower, for your help. Right, the next item will be item number 9, which is petitions for review of administrative judge initial decisions. These were materials that were included separately in your packet. Mr. Pope.
Due to their size, they're quite large and have the audio recordings that were shared via Microsoft OneDrive. So all of the appeals on this agenda item have previously been heard by an administrative judge. At the prior hearing with that judge, every party had an opportunity to submit proof, testimony, documents, or otherwise develop the administrative and evidentiary record. The administrative judge then renders a full written decision with their factual and legal conclusions based upon the evidence presented. And unless a party appeals or you as the board elect to review a decision, that administrative judge's decision otherwise becomes the final agency action. Parties may, but are not required to appeal to you as the board before seeking relief in Chancery Court. The appeals before you are those who have elected to petition you as the board for intervention before that decision becomes final. You as the board have pretty broad discretion in what actions you'd like to take. You can decline to exercise review in its entirety. This still permits either party to seek further judicial review. And then that means the decision of the administrative judge will otherwise become the final agency decision. You may also delegate your review to one or more persons, or delegate that review subject to additional adoption by you as the board. You've got several different, sort of a broad range. You are permitted to hear oral argument from the parties before making a decision, but you are not required to. I did receive, as a note, I will say, one request from Mr. Anderson on behalf of Anderson and Margarita Young versus the Madison County Assessor's Office. However, the presence of one of the parties would only truly be necessary if you as the board want to hear those oral arguments from the taxpayer or from the appellant. If you otherwise decline to exercise review, you don't need to delay action from this meeting because of that. And I did my best to explain that to Mr. Young prior to today as well. And he can watch today's proceedings within 3 business days online.
Okay, before we get into this, I had one question, which was one of the commenters here today talked about the fact that the Assessment Appeals Commission had expired and made recommendations. I believe Mr. Scruggs made that recommendation. Does the Division of Property Assessment or anyone else have any points of view about that recommendation that he is making? He pointed out that, not everybody, I guess, has the financial wherewithal to go to Chancery Court, et cetera, and sometimes everyone is human and they make mistakes. That includes administrative law judges, I guess. But he was also pointing out the need for the record to be reviewed. If we're going to hear these things ourselves, be reviewed more thoroughly. So I just wondered what comments we might have about his comment. So
I have not received any other comments of that particular variety that I can recall offhand. We do have a couple people from the Division of Property Assessments if you'd like to hear from them. I believe their division is their division director is absent today. He's I think working elsewhere. But we do have our assistant director, Mr. Brower, if you'd like to give any comment.
all right. Sure, Mr. Brower.
Not aware budget-wise the cost that it would take to go to the AAC. I'm not sure the answer to that question.
Okay, but I mean, I guess the point is is it something that is or is not merit-worthy to have an assessment appeals commission as such, in the process between the ALJ's decision and what this board might ultimately do with a particular case?
The opinion of the Division of Property Assessments is that it's not a merit.
All right.
I could maybe elaborate on some other points on that as well. So the commission, their review was also always discretionary. You didn't have to go to the commission before going to the Chancery Court, as well as some of these proceedings coincide with updates with the open meetings requirements. And so even with the commission, there was still this exact proceeding would have happened with optional petition for the state board review before going to Chancery Court. So some of the procedure you're seeing today has more going to coincide with updates to open meetings requirements rather than really the dissolution of the commission.
Okay, board members, do you have any questions about that or anything, issues with that? All right, thank you very much, Mr. Brower. And on the question or the comment rather that Kelsey Jones had about this case, the Cross Creek, Tennessee LP case, where you spoke of sales chasing. Would you come back up here just a second, Kelsey, and let's ask you one little question here. I've looked at some of the papers on this, but I've not reviewed the audio tapes on these appeals or anything. But was sales chasing discussed or raised to the administrative law judge here? You indicated that the failure to consider sales chasing was a serious issue.
Yes, sir. Mr. Chairman, beginning with the original appeal and also with statement of facts and law in support of the original appeal, we have pointed out that the major concern was the sales chasing and the fact that it appeared to involve the singling out of taxpayer property and 5 others, while other properties that recently sold were not adjusted. The values were not adjusted, nor were values generally adjusted in response to those sales. So it would be taxpayers' view that there was no effective review by the administrative judge on that issue. We appeared at what had originally been scheduled as a pre-hearing conference, which was converted to a hearing on the procedural issues. We viewed the sales chasing as a substantive legal question. I had a witness available and also the exhibit, which is part of the materials you have in front of you all that illustrates the effect of that sales chasing. But it did not appear to be considered. It was certainly not addressed in the initial decision and order. There was merely a finding that there was no remedy in the state statutes for that particular offense. And of course, in my argument today, I have pointed out that the statute does address the duty, even if you will, of the board to address, in the name of good equalization, any actions of the county board or the assessor that disturb the reappraisal values in a way that seems objectively unfair and discriminatory. So we would believe that we did not get a hearing on that aspect of the case, and that's the most important aspect.
Is there is reason that you contend that you didn't get a hearing on that the administrative law judge did not take proof on that matter? You said you had a witness, and that witness was not permitted to testify, et cetera. And then my second question about that is, did you submit any affidavits? As you know, if you can't have a witness heard, then you can always submit an affidavit to the court.
Yes, sir. Had the witness present, Mr. Catanani, who I believe is participating remotely today, but was not allowed to call the witness. The judge proceeded to hear arguments. The assessor's argument was that regardless of how the assessment changes had been accomplished, it could be remedied by a hearing before the state board on value, which missed the point that we were trying to make, that there was an illegal change in those assessments that had been ruled discriminatory by the U.S. Supreme Court. And that was only addressed in a single sentence in the judge's initial decision order, saying that there was no statutory remedy.
But when you were denied the ability to present a witness, you didn't submit an affidavit,
I
right?
had the witness there at that hearing.
But the court didn't hear the witness's testimony, is your
Correct.
point. And could have submitted an affidavit with that testimony in it, right?
There was no, the judge did not leave the record open for any further submissions of proof. An affidavit, of course, is often submitted in response to, or it's a part of a motion,
Right.
kind of give the tribunal an idea of what they're going to see. But we didn't view it as a substitute for live testimony, and as well as the discovery that can and should have preceded that hearing. It did not, because it was originally scheduled as a pre-hearing conference. So we believe there was no effective opportunity to provide evidence in support of what is a very important point and claim.
Do members of the board have any other questions about this line of questioning or anything? Okay. Thank you, Mr. Jones. Okay. All right. Any discussion about these items which are shown?
Mr. Chairman, Kelsey, I probably actually had a question about the next item, the Westminster Chapel case. I mean, it seems like the issue at hand is not necessarily a valuation issue. Yeah, I reviewed materials. In a nutshell, again, what is your issue there?
There are three precedents that grant relief from the May 20 exemption application deadline, where there's words or action of the assessor or the assessor staff inadvertently caused the taxpayer to delay. In this case, the taxpayer, at about the time they began construction, called the assessor pursuant to instructions in the assessor's website, and was simply told, you don't have to worry about filing the application until you're closer to completing the construction, which was wrong. There is an assessment, interim assessment on materials at a construction site even before the property is completed, and there is a rightful claim to exemption for that can extend back to that. So in this particular case, the taxpayer failed to file the application until shortly after the May 20th, 2020 deadline. There were two other instances. In one instance, the assessor did not make a pro rata assessment on materials on site. And in one of the precedent cases, the judge pointed out that, well, had that occurred, had the assessor made that interim assessment, it would have prompted the taxpayer in that case to proceed with the application. So our case is on all fours with that particular shortcoming. And then the final concern was COVID, because as you all remember, in spring of 2020, the assessor trying to get out notices of value by May 20th, the taxpayer is trying to meet their obligations, and there were widespread closings of offices, including the assessor and the local zoning apparatus to approve occupancy permits and that sort of thing. So there were at least three bases that we believe should have offered relief from the deadline. One other point, if I may please mention this, it appears from the documents that the assessor's interim assessment for 2020 was at full value of the property. Since the property had not been completed by January 1 of 2020, the assessment should have been limited to the value of materials on site. So there's an apparent error there. Normally, we would ask, and are asking in this case, that the church be allowed to simply amend its complaint so that we can investigate that situation. It may be that the assessor, they objected to an amendment, but if asked to look at it, I'm sure the Metro Assessor's Office would be happy to correct an error in the 2020 assessment insofar as it represented the value of the entire property rather than just the material on site.
Thank you.
And the board does have discretion to allow amendment of a complaint in those well, not just in those circumstances, but in any situation where justice seems to require.
Members of the board, any discussion on these items?
You also have members from the assessor's offices for both those cases if you want to hear from the opposing party.
Okay, do we have parties from or persons from the assessor's office who want to be heard?
Yes.
Yes, sir. Come on forward then.
Before we begin, I just would interject too that the agenda item for today is to decide if the board wants to grant review or if they want to delegate that review further.
First, if you state your name and identify yourself. There you go. Okay.
I'm Charlie Starkey. I'm with the Knox County Law Department. And I'm
You're here on Cross Creek TNLP versus Knox County Assessor.
Cross
Okay.
Creek.
All right.
I just wanted to point out the opinion issued by the administrative judge dealt specifically with a procedural issue. There was an order bifurcating the case before the hearing was held back in November. And the issue was, at one point, the taxpayer said, you didn't give us notice so we could appear before the county board. Therefore, your assessment's void, period. We pointed out, as the judge set out in her opinion, that the statute, particularly 675-508B2, indicates that if a taxpayer does not get notice within 10 days before the county board ceases its session, that it has the option of coming to the state board, and that either upon the request of either party or the decision of the state board, the matter can be returned to the county board for a full hearing. We made that argument that it was not void. In fact, the statute 508B2 specifically says just because you don't get notice, it does not void the assessment. The assessment is held in abeyance as long as the taxpayer pays taxes on the portion that is not an issue, which according to our review has been done. So that's not an issue. But still, what the judge did in this specific case on a narrow issue that was the only thing before the judge pursuant to her earlier order of bifurcation, she said, this goes back to the county board for discovery, which has been requested, and for a full review of this situation. That's what the county board is there to do. That's what the judge said needed to be done. There was no proof on the substantive issues. That's correct. But the judge specifically said in her ruling on page 4, I think it is, constitutional issues are very important. Yes. Constitutional issues, constitutional rights are protected by statutes. And this statute 508B2, which says this board can hear it, a full hearing, or you can send it back to the county board. protects those constitutional rights. So on those basis, we say that what the judge did is correct. Respectfully ask that the court, at this body, I'm sorry, not take any review, take any action. Thank you.
You also have Miss Lexi Ward from the Davidson County Assessor's Office has raised her hand in the virtual audience.
Okay. Ms. Ward, you'll be recognized.
Thank you. Good afternoon. Lexi Ward with Metro Legal. I represent the Davidson County Assessor of Property in the matter of the Westminster Chapel appeal that Mr. Jones was just speaking to you on. Respectfully, it is a bit of a mischaracterization of what has already occurred in this matter. Previously, two separate ALJs have already actually reviewed this matter. Both have found that there was no legal justification for an exemption pursuant to the statute. First, it was before Judge Cochran. There was an appeal to the Assessment Appeals Commission where Mr. Jones then entered the matter, presented several cases for review. The Assessment Appeals Commission then remanded to Judge Padfield, who then wrote a very detailed order that considered every case. She actually wrote a review of every single case and how it does not apply to this case and how there is no legal justification for an exemption and how this case does differ from the cases that Mr. Jones is now asking this body to revisit again. It was made clear that no actions by the assessor. She states that that the statement from the assessor's office was not the cause of the untimely filing of the application for exemption, and that indeed Westminster relied upon the statement, and that was not justified and not a reasonable justification for submitting untimely. Additionally, as Mr. Pope has already informed this board, the parties have already been made argument, have been permitted to build the record. Indeed, Westminster has had two bites of that apple now and has built almost two separate records for this board to review. Both have come to the same conclusion. So any new arguments or facts that Mr. Jones attempts to raise at this point have already, it's a bit too late for that. But again, happy to address anything that this board would like us to address. And to speak to the request for an amendment to add a valuation determination to this exemption appeal, we have found no case law and no support in jurisdiction for that sort of an amendment because they're two separate paths on how to file for an exemption and how to file for a valuation appeal. It is actually about 3 years too late to file an evaluation appeal. And so we would believe that an amendment to bypass both the local board and all of the other procedural jurisdictional requirements for a value appeal at this point would be too late and sort of pigeonholing a value appeal into an exemption appeal inappropriately. So we would ask this board to deny the petition for consideration of this matter. Thank you.
Any questions of Ms. Ward, members of the board? Seeing none, thank you, Ms. Ward, for your comments. Okay, we're back on the item here, which is on our agenda, item number 9, petitions for review of administrative law judge initial decisions. And we have 6 cases here. Any comments or discussion among the board about these matters? From my perspective, I'll comment that on item case number 3, which is Cross Creek TNLP versus Knox County Assessor, I would like to continue that case to the next meeting to take a further look at this. The others, I'll just comment that, based on what I've heard here today and had my own review of the papers in these cases, as I said, I haven't sat down and listened to all of the entire audio record on all of them, but to me, they seem to be such that we need to decline to review those. That's my view, and I'll be happy to discuss that in conversation with members of the board here in this meeting.
Mr. Chairman,
Yes.
in that our thinking is similar, I'll make a motion to refer case number 3, the Cross Creek case, to the executive secretary for review and advisement at the next meeting and move to decline to hear the other 5 cases.
All right. Motions, there a second?
I have a question.
Yes, Ms. Burchett.
Kelsey said in the Westminster Chapel case that while they were still under construction, they were valued at full value. Did I misunderstand that?
Correct.
While they were still in the construction phase?
Yes, sir.
I have a little issue with that. full value when they're still under construction and not in use.
We could amend that motion to include the Westminster case to be referred to the executive director. Further review.
Mr. Chairman, I'll be happy to restate my motion to refer cases 3 and 4, the Cross Creek case and the Westminster case, to the executive secretary for review and advisement at the next meeting. Decline to hear the other cases.
All right, that's satisfactory, Ms. Burgess. All right. Is there a second? All right, Commissioner Geragano seconds that motion. So the motion would be to refer the case Cross Creek TNLP versus Knox County Assessor, and item number 4, Westminster Chapel DBA Stevens Valued Church versus Davidson County Assessor to the executive director. Further review as to the other cases, which is number 1, Janice L. Bryant versus Davidson County Assessor's Office, and number 2, Ronald L. and Clementine Newman versus Shelby County Assessor's Office, and item number 5, Anderson and Margarita Young versus Madison County Assessor, and item 6, Wright Elsian Fields Partnership versus Hamilton County Assessor. The board would decline to review those cases. Any further discussion? Seeing none, we have a motion and a second. Yes.
I was one of the audience members. I don't
Okay.
know who that commenter is.
This
Could you identify
William
yourself and?
Sure. This is William Wade. I am attending because I thought that our property, my mother's property, will be reviewed, but it sounds like it's not going to be reviewed. Am I understanding this? This 2105 Lindale Avenue, Nashville, Tennessee.
So Mr. Wade, you are the representative for, I believe, our first appeal on that list, Ms. Janice L. Bryan versus the Davidson County Assessor's Office. The
Right.
board has the option to hear from the parties, and so I will refer to the Vice Chair Lillard. Vice Chair Lillard, would you like to hear from the appellant taxpayer on behalf of Janice L. Bryant?
I'll ask the board for its inclination as to what to do. Would you like to hear from the gentleman?
Yes.
All right, then Mr. Wade, we'll recognize you for, let's make your comments, keep it to 2 or 3 minutes, okay?
I really appreciate it. Thank you.
Okay, please
Okay,
proceed.
Thank you. I'll make it real quick. The values that the assessor's office that they are trying to use, they're just totally out of the ballpark. For example, the square footage for one of the comps don't even exist. It appears that the appraiser just pulled it out of thin air. They have the comp 1 listed at 1248 square foot. It doesn't even exist on the assessor's website. I don't know where he got it. The true square footage is 1494. There's another comp out of the 3 that they use. The assessor used 1428. The true square footage is 1576. Essentially, what I'm getting at is that this assessor, they're using an appraiser to just pretty much pull some values in their favor, and it's unsubstantiated. One other quick thing that I would like to say is that they also used a house that sold in 2022 when it appears to be that the state law only allows houses that sold in the year 2020, based on this, what I'm trying to get across to you guys as far as the law here. So I just want to throw that out there because, there's obvious that there's a abuse of discretion here where they're over appreciating the subject property and under appreciating the comparables. And I've included affidavits from repairmen. We have firsthand knowledge of the condition of this house for review. And, we just need to be fair and stick to the law on this. I appreciate you guys' time.
Thank you, Mr. Wade. Did you participate in a hearing with the administrative law judge in this case?
I did, yes, sir.
And you made these arguments, is that right?
I made the arguments, specifically as far as the, 12, when we're talking about the specific square footage, that was, I guess that would be the appeal in the initial order that he reviewed, through paper. But I did raise the argument of the using of the house from the sales from 2022 when, that's not even permissible.
But you had the opportunity to make other arguments as you felt appropriate, correct?
Yes, I did. And I did make those arguments.
Okay. All right, members of the board, do you have any questions of Mr. Wade here? Mr. Ward, excuse me. Wade, excuse me, William Wade. All right, Mr. Wade, thank you for your help, okay, today. All right, thank you. We'll proceed here with, we made a motion and had a second for it there, and I would ask to call the question on the motion here. So is there any objection to that? Seeing none, all those members in favor signify by saying aye. Aye. Those opposed, no. The ayes have it and the matter is adopted. Motion previously made, seconded. All right, next item is item number 10, which is February 22, 2024, letter to the board by National Health Investors, Inc. and Asbury Centers, Inc. Pages 20 through 114 in your materials. Mr. Pope, if you want to present this item.
I should clarify that this isn't necessarily an action item for the board. It was put on consideration in response to the letter I believe you all received.
Right.
The board is not required to take any action during this meeting on we've already heard from Mr. Carter as well regarding this matter. Additionally, I would just make the board aware that both National Health Investors and Asbury Centers have filed petitions for judicial review, and have identified that they are contesting this tax year 2022 in their separate petitions. So both these are current. This matter is somewhat related, is related to current ongoing litigation in Chancery Court. Unless you have additional questions for myself or would like to go into any additional background or recall Mr. Carter for additional questions, you may otherwise proceed to action item 11, which would be adjournment.
Mr. Chairman,
Yes.
I would just say that in regard to this matter, that it's in court with work being done by both parties. It's my understanding that if a chancellor agrees with the assertion in the letter, it can be remanded back to this board and that no action is necessary at this time.
Okay. Any other discussion on this item? All right, seeing none. Do you have anything else for the board today, Mr. Pope? All right.
That contains our entire agenda.
Chair moves to adjourn. Is there a second?
Second.
Motion second. Comptroller, Maria, second by the comptroller. All those in favor of adjournment signify by saying aye. Aye. Those opposed, no. The ayes have it. You're adjourned. Thank you for your service.